Non-conventional trademarks offer a way to protect the look and feel of a brand. Although individual components of a brand, such as its color, can be difficult to protect, something I'm going to discuss separately in the future, it may be easier to secure other types of protection. One that goes a long way towards maintaining the uniqueness of the look and feel of your brand. So don't assume that trademarking a name or logo is the only type of protection that's available for a brand. An interesting example of a non-conventional trademark is Apple's protection of the layout of its stores. Now, it secured a trademark from the US Patent and Trademark Office, and then, having secured this trademark, Apple sought to extend its protection internationally. However, it hit a problem in Germany, whose trademark office refused to grant protection on the grounds that consumers wouldn't regard the sign as a trademark in the sense of indicating the trade origin, the source of those goods and services. The depiction of the space devoted to the sale of Apple's goods was nothing more than a representation of an essential aspect of Apple's business, said the German Trademark Office. Apple appealed, and the decision was referred to the Court of Justice of the European Union, that's the CJEU. In a groundbreaking decision, the CJEU held that the representation of the store layout was in fact capable of distinguishing the goods or services of Apple's business from those of other undertakings. In this context, it was relevant whether the depicted layout was distinctive and different from the norm or customs of the computer sector. Now, whether a design representing the layout of a retail store is distinctive enough to be registrable has to be assessed by reference to the goods or services in question and with regard to the perception of the public. So, for example, if you want to protect your restaurant or shop layout, the assessment criteria that the IP office would need to apply would be to consider whether that layout is different to what you'd expect a restaurant or shop of that type to look like. Applications must always be assessed on a case-by-case basis. So, in conclusion, if you want to create a commercial establishment with distinctive layouts which are not solely functional, which can be a highly useful form of protection for consumer businesses operating, for example, through a franchise model, I recommend involving an experienced trademark lawyer during the design phase to bounce off ideas to see whether the interior distinct arrangement of your internal layout is likely to meet the criterion by which the courts would decide the application. You see, experienced trademark lawyers can add much more value than simply clearing a trademark or registering one. I get a good feel for what is protectable and distinctive through my work in registering or disputing trademarks. So by involving someone like me in the creation stage, you're much more likely to choose elements like names, logos, or other designs that are sufficiently distinctive to be worth using and applying to register. If you just relegate a lawyer to a role of protecting what has already been created, you don't get the lawyer's input to help you to choose well and create the right branding elements for your business. As such, there is a risk of increased or wasted costs even Non-conventional trademarks in particular need to be considered carefully with a lawyer during the creation stage.